Sections 4 and 5 of the Voting Rights Act were passed in 1965. They are unique provisions in that they require jurisdictions that are covered by the statute to submit any changes with respect to voting to the Department of Justice or the D.C. Court for pre-clearance to ensure that they didn't worsen the position of racial minorities. The original coverage formula was based on the presence of a test or device and voter turnout below 50% in the 1964 election, then later amended to include some other elections. The test or device definition was later amended to include jurisdictions with large non-English speaking populations that had ballot materials only in English. Jurisdictions that were covered under the Voting Rights Act, as I said, would have to pre-clear their state laws or local laws to the Department of Justice or the U.S. District Court for the District of Columbia. In order to get out of the pre-clearance regime, you had to show, among other things, a good voting rights record for the previous 10 years. There was also the possibility that some jurisdictions that weren't covered could be bailed in by court decree. In 2006, the version of the Voting Rights Act, which was considered in Shelby County, was passed by Congress. It kept the same coverage formula as it existed before that. It, at the same time, overturned two other Supreme Court decisions, Georgia versus Ashcroft and Reno versus Bossier Parish, such that when a jurisdiction submitted its laws for preclearance to the Department of Justice or the U.S. District Court, it had to show that there was no discriminatory purpose and that there was, it did not diminish the ability of a racial group to elect its preferred candidates of choice. So that's a very short summary of a very complicated law. But the case itself, brought in 2010, filed by Shelby County, Alabama, which was at one of the covered jurisdictions. Most of the covered jurisdictions are in the South, but not all of them. They challenged Sections 4 and 5 of the Voting Rights Act. They, unlike in an earlier case, Northwest Austin Municipal Utility District, this jurisdiction was not eligible for bailout because there had been a denial of preclearance within the previous 10 years. The District Court and the Court of Appeals upheld the VRA, finding that the coverage formula was adequately supported by the record that Congress had developed, and the Supreme Court reversed in a 5-4 decision. The 5-justice majority struck down Section 4 as exceeding congressional power to enforce the 15th Amendment. I should make clear that Section 4 is the part of the Voting Rights Act that is the coverage formula, what jurisdictions are covered and what are not. Section 5 is the preclearance regime, setting forth the criteria by which the covered jurisdictions need to get permission from the federal government. So it struck down last week by a 5-justice majority. They found that the coverage formula was not supported by adequate evidence in the record. They found the selective treatment of certain states by the coverage formula to violate what they call the equal sovereignty of states. In particular, when looking at the record, they focused on the reduction in the racial gap in registration and turnout as strong evidence that the coverage formula was outdated, and found that the current burdens of the VRA didn't match the current needs, such that Section 4 is not, depending on the term, it's not rationally, logically, or sufficiently related to preventing the present-day challenges to minority voting rights. There was a concurrence by Justice Thomas, who would have struck down Section 5 as well as Section 4, so not only the coverage formula, which jurisdictions were captured by the Voting Rights Act, but also the criteria for preclearance. He would have struck that down as well. 4 justices joined in a dissent written by Justice Ginsburg. They find that the reauthorized VRA would have passed what we call rationality review, or the standard set out in McCulloch versus Maryland, that this was an appropriate means toward fulfilling a constitutional end. They, in particular, would have found that reauthorized statutes are very likely to satisfy this kind of judicial review, because there's an initial record that was upheld by the court in the initial Voting Rights Act, that there was also a temporal limitation in the act that ensured that Congress would continually reconsider it, and that the deterrent effect of the law would naturally lead for a lessened congressional record in a reauthorized statute than it would in the initial statute. They viewed the 15,000-page record as sufficient to maintain coverage. That record, the elements that they point to are the rates of preclearance denials by the Department of Justice, the deterrent effect of the preclearance regime, the insufficiency of another part of the Voting Rights Act, Section 2, to accomplish the tasks, as well as academic studies that looked at the rate of Section 2 violations. And they also point to greater racial polarization in the covered as opposed to the non-covered jurisdictions. Whereas the majority focused on turnout and registration, the dissent focused on second-generation barriers, particularly things like racial-based vote dilution. And they also considered bailout and bail-in as important measures to ensure that the coverage formula was not rigid. The dissent particularly criticized the majority for not thinking about whether the law could be applied in particular to Shelby County, Alabama, even if other jurisdictions that might be unconstitutionally covered. And then finally, they disagree as to what the equal sovereignty doctrine means, suggesting that it's not about disparate treatment toward the states, but it's more about the admission of states into the union. So just by way of conclusion, this court strikes down Section 4 of the Voting Rights Act, leaves Section 5 preclearance for another day. But as a consequence, the covered jurisdictions no longer need to submit changes in voting to the DOJ or the district court. What this means going forward, we'll discuss how it applies to Section 5, Section 2, other civil rights laws, the importance of it as precedent. But that's your thumbnail sketch of what the Supreme Court did last week.